UK ILR Reform 2026. Earned settlement, legal history, and what it means. Introduction. Welcome to this discussion on the UK's proposed reforms to indefinite leave to remain, commonly known as ILR or settlement. This transcript covers the earned settlement proposals, the legal history behind retrospective rule changes, and what this means for skilled worker visa holders currently in the UK. This content has been fact-checked against official UK government publications, Home Office immigration statistics, the National Audit Office, House of Commons library briefings, and relevant High Court judgments. How many skilled worker visa holders are not extending? There is no single official figure published by the UK government that tells us exactly how many skilled worker visa holders chose not to extend, allowed their visas to lapse, or left the UK without notifying the Home Office. What the data does show is the following. In the year ending March 2025, approximately 103,700 skilled worker visa extensions were granted to main applicants, and around 434,000 work visa extensions were granted overall. Extensions have been increasing as more long-term workers reach the point of renewal. However, the refusal rate has risen sharply. In 2024 to 2025, the skilled worker visa approval rate dropped to approximately 79%, meaning roughly 21% of applications were refused. This is a dramatic change from previous years when approval rates were as high as 99% and refusal rates sat at just 1 to 2%. In absolute terms, approximately 27,529 skilled worker visa applications were refused in 2025. The National Audit Office confirmed that this increase is largely driven by the salary threshold rising from £26,200 to £38,700 in April 2024, along with tighter compliance checks on sponsors. The total number of certificates of sponsorship issued for the skilled worker route fell by 42% year-on-year, from 422,832 in 2023 to 2024, down to 243,651 in 2024 to 2025. It is important to note that the Home Office does not publish figures for people who simply leave the UK when their visa expires without applying for an extension. There is no exit tracking system that captures this data comprehensively. The proposed ILR reforms. Earned settlement. The UK government launched a public consultation entitled A Fairer Pathway to Settlement, Earned Settlement on the 20th of November, 2025, which closed on the 12th of February, 2026. The consultation was led by the Home Office under Home Secretary Shabana Mahmood. The core proposals are as follows. First, the standard qualifying period for settlement would increase from 5 years to 10 years for most work and family visa routes. Second, settlement would no longer be an automatic entitlement based purely on time spent in the UK. Instead, it would be earned through demonstrated contribution and integration. Third, the new system introduces 4 assessment pillars. Character, involving stricter checks on criminal history and debts to the NHS or government. Integration, requiring a higher English language standard at B2 level and a Life in the UK test. Contribution, requiring proof of stable employment, minimum earnings of at least £12,570 per year, and regular national insurance payments. And residence compliance, requiring continuous lawful residence, although time alone would no longer be sufficient. Fourth, accelerated settlement would be available for high earners, those earning between £50,270 and £125,140 or above, and for some key public sector workers and those in shortage occupations. These individuals could qualify in 3 to 5 years. Fifth, use of public funds or social welfare could add 5 to 10 years to the qualifying period for settlement. For those in lower skilled roles or with a history of claiming public funds, the qualifying period could extend to 15 or even 20 years. Estimates suggest that between 2026 and 2030, up to 1.6 million people could be affected by these changes, with the peak impact expected around 2028. As of February 2026, the consultation has closed but no new law has been enacted. The existing 5-year ILR route remains in force until new rules are formally laid before Parliament and come into effect. The earliest possible implementation date is expected to be April 2026. Why the UK government wants to reform ILR. The government has given several reasons for proposing these changes. First, controlling long-term migration numbers. Settlement is viewed as a major driver of permanent migration. By extending the qualifying period, the government aims to slow the transition from temporary to permanent status. Second, linking settlement to economic contribution. The reforms are framed as making settlement a privilege earned through work, tax payments, and community engagement, rather than an automatic right based solely on the passage of time. Third, managing pressure on public services. Supporters of the reform argue that large numbers of people settling permanently increases demand on healthcare, housing, education, and the benefits system. Stricter criteria are intended to manage these pressures. Fourth, responding to recent record migration levels. After record visa grants in 2022 and 2023, particularly health and care visas, projections indicate that millions of migrants could become eligible for settlement over the next decade under current rules. The government argues that without structural change, settlement volumes would rise unsustainably. The retrospective application debate. The most controversial aspect of the proposals is whether the new rules would apply to people already living in the UK who have not yet obtained ILR, including those partway through the existing 5-year route. The government's stated position, confirmed by Home Secretary Shabana Mahmood, is that the new rules would apply to everyone who has not already been granted ILR at the point the new rules come into force. Mahmood has explicitly denied that this constitutes retrospective application. Her legal argument rests on a principle that has been embedded in UK immigration law since approximately 2009, that settlement applications are assessed under the immigration rules in force at the date of application, not the rules that existed when the applicant first entered the UK. Under this framework, no applicant has a legal right to settlement until ILR is formally granted. Until that point, they hold temporary leave to remain, and any future application, including for settlement, will be judged against whatever rules are in force at the time they submit it. The HSMP case. Why 2009 matters. To understand why the government insists this is not retrospective, it is necessary to look at the legal history, specifically the landmark High Court case known as HSMP Forum Limited v. Secretary of State for the Home Department, decided in 2008. The Highly Skilled Migrant Programme, or HSMP, was a pre-2008 immigration route that allowed skilled workers to come to the UK. In 2006, the Home Office introduced significantly stricter criteria for HSMP holders seeking to extend their stay. Critically, these new criteria were applied to people who had already been admitted under the original, more lenient rules. HSMP Forum Limited, a representative group, challenged this in the High Court. In his judgment, Mr. Justice Foskett held that the retrospective application of the new rules was unlawful. He found that applicants under the earlier HSMP scheme had a legitimate expectation that the original rules would continue to apply while they remained within the scheme. Applying stricter criteria to people who had made life-changing decisions, relocating their families, leaving jobs in their home countries, based on the original rules was, in the court's view, conspicuously unfair. However, the court also confirmed that the government was entitled to change rules for future applicants. The ruling only protected those already admitted under the earlier policy. This judgment was significant because it established that immigration authorities must act fairly toward people who have already entered under a particular set of rules. The doctrine of legitimate expectation, that where a public body has adopted a clear policy, individuals are entitled to rely on it, was central to the decision. How the government responded after the HSMP defeat. Following the HSMP judgment, the Home Office took steps to prevent similar legal challenges in the future. From approximately 2009 onwards, the immigration rules were explicitly codified to establish that all applications, including for settlement, would be assessed under the rules in force at the date of application, not the rules in force at the date of entry or initial visa grant. This change was deliberate. It was designed to remove the legal basis for legitimate expectation claims of the kind that succeeded in the HSMP case. By making clear in advance that rules could change at any time and would apply to all future applications, the Home Office effectively created a legal framework in which no applicant could claim they were promised settlement under any particular set of criteria. This is the principle that Shabana Mahmood relies on when she states that the earned settlement proposals are not retrospective. Her position is that the law has been clear since 2009. You apply under the rules that exist when you apply, not the rules that existed when you arrived. Why immigration lawyers disagree. Many immigration lawyers and campaigners continue to argue that while the government's position may be technically legal, it is substantively unfair. Their arguments include the following. First, legitimate expectation in practice. Even if the law permits rule changes, migrants made major life decisions, accepting job offers, moving families, buying property, enrolling children in schools, based on a clear and widely publicized 5-year settlement pathway. Changing the goalposts partway through undermines trust in the immigration system. Second, proportionality. Applying a 10-year requirement to someone who has already completed 4.5 years of a 5-year route is disproportionate. The additional burden is enormous relative to the small remaining time under the old system. Third, impact on families and children. Dependents, including children born or raised in the UK, would face years of additional uncertainty, affecting housing stability, education, and mental health. Fourth, parliamentary opposition. Over 50 members of parliament, including some from the governing party, have formally urged Mahmood not to apply the new rules to people already in the UK, arguing it would damage the UK's international reputation as a destination for skilled workers. However, it is also fair to acknowledge that immigration is a competitive professional field. Some lawyers may emphasize uncertainty in ways that encourage potential clients to seek paid legal advice. Both genuine legal concern and commercial incentive can exist simultaneously. The strength of the legal argument should be assessed on their merits, not dismissed because lawyers have a financial interest in immigration cases. The critical point is this. UK courts have historically given Parliament wide power to change immigration rules. Courts rarely block rule changes unless they are found to be irrational or discriminatory. So while the fairness arguments are strong morally and politically, they may not succeed as legal challenges, precisely because of the post-2009 codification that was designed to prevent them. What this means for a skilled worker who started in June 2021. For someone whose skilled worker visa started in June 2021, the current position is as follows. Under the existing rules, which remain in force as of February 2026, the 5-year qualifying period would be reached in June 2026. An ILR application could be submitted up to 28 days before that date, around late May 2026. Because this visa was granted before the April 2024 salary threshold increase, transitional salary arrangements apply. The ILR salary requirement is generally lower than the new £38,700 threshold that applies to post-April 2024 applicants, though the applicant must still meet the going rate for their specific occupation code at the point of settlement. The key uncertainty is timing. If the new earned settlement rules come into force before an ILR application is submitted, the application would be assessed under the new criteria, potentially requiring a 10-year qualifying period and higher integration and contribution standards. If the application is submitted while the current rules are still in force, it would be assessed under the existing 5-year framework. No transitional protections for people close to the 5-year mark have been confirmed. The government has sought consultation responses on this question, but no decision has been published. The practical advice from most immigration advisors is, if you are close to qualifying under the current rules, submit your application as soon as you are eligible, before any new rules take effect. The broader context. Trust in the immigration system. This debate ultimately goes beyond technical legal questions. It touches on something fundamental, whether the UK immigration system can be trusted. The UK actively recruits skilled workers from around the world, particularly in healthcare, engineering, and technology. Those workers make significant sacrifices to come, leaving established careers, uprooting families, paying substantial visa and health surcharge fees. If the terms of settlement can be fundamentally altered midway through the process, the risk is not just to the individuals affected. It is to the UK's ability to attract talent in the future. Countries including Canada, Australia, and Germany compete for the same skilled workers, and the perception of fairness and stability in immigration policy is a factor in those workers' decisions about where to build their lives. At the same time, the government has legitimate concerns about managing long-term migration, ensuring fiscal sustainability, and maintaining public confidence in the immigration system. These are not trivial considerations. The challenge is finding a balance between policy flexibility and individual fairness, and that balance has not yet been struck in the current proposals. Conclusion. The proposed UK ILR reforms represent the most significant change to settlement rules in over a decade. The shift from a time-based 5-year route to a contribution-based earned settlement model could affect up to 1.6 million people currently in the UK. The legal framework that allows this change dates back to the aftermath of the 2008 HSMP High Court judgment, when the Home Office codified the principle that applications are assessed under current rules, not historic ones. Whether this is fair, morally, socially, and politically, remains deeply contested. The consultation has closed, but no final rules have been enacted. For anyone affected, the most important action is to understand eligibility under the current rules and, where possible, to submit applications before any new framework comes into force. Thank you for listening. Sources: gov.uk Earned Settlement Consultation, November 2025. Home Office Immigration Statistics. National Audit Office Report on Skilled Worker Visas. House of Commons Library Briefing CBP 10267. HSMP Forum Limited v Secretary of State for the Home Department, 2008, EWHC 664 Admin Davidson Morris Earned Settlement Guide. Sterling Law Parliamentary Update, February 2026. Immigration Barrister UK Analysis. Business Standard, February 2026.